Hi, good afternoon to everybody. Welcome to this webinar of the UIA Fashion Law Commission. It's an absolute privilege for us to present this to all of you, and I hope that you enjoy this session. Today, we are going to speak about 4 out of the 6 topics that are the cutting-edge topics nowadays for the fashion industry in the context of COVID-19. COVID-19 has hit all the economies and all the industries, but fashion has been one of the most heated sectors of them all. This is so because fashion is a worldwide international industry, and now we are in a situation with our borders worldwide practically closed, which is causing a lot of troubles in regarding distribution, supply chain, manufacturing, etc. We will talk about this. But also, it's an industry that it is very based still on brick and mortar and retail stores. Of course, with the sanitary measures taken across Europe, but also in the United States and in other jurisdictions, this has caused a severe impact on our clients on the fashion industry who cannot sell their products to their customers as they used to. This has caused a very severe crisis that our clients are trying to manage. This, together with several regulatory changes in different countries worldwide, has completely shaped the regulatory framework of fashion industry in these very recent times. So as I was saying, today we are going to talk about 4 out of the 6 more relevant topics. We are going to speak about rental agreements, which is a key element in this context. We are going to speak about distribution and agency. We are also going to speak about e-commerce, which is mostly the only living channel that most fashion houses have in this context. And finally, we are also speaking about the reconversion of the industry, temporary conversion to produce health-related items. As I was saying, these are 4 out of the 6 topics that are more relevant. Of course, there are other 2 topics on the table, which would be labor law related issues and financing issues, but it was impossible to talk about the 6 of them in a single webinar, and I'm sure that we can discuss them in future seminars. So without further delay, I'm going to introduce our first speaker. Our first speaker today is Milagros POAL-MANRESA. She is a member of the Fashion Law Commission. She's the former president of the Contract Law Commission. Milagros is partner of the law firm ADRSynergies, and she's an expert in contract law, rental agreements, and as well as in mediation. Milagros, the floor is yours.
Okay. Thank you, Javier. Thank you very much for giving me the chance of being here today with you all. Hope that this situation of the presentation is interesting. My idea here is to treat this subject in a very practical way, and hopefully I can make it short as possible and to have an overlook of the whole situation. But bear in mind that we are in an international seminar, and I don't want to talk only about internal jurisdictions. So with no further issues, I'm going to go back to my presentation. Okay. As we see here, the virus has gone global, closing stores and shutting in customers and consumers. But there is hope for the future, as well as signs of more travel ahead. So we have, for first thing, I would like to put into the table the issue that arose in Germany with Adidas, the brand, who on the first place just went back to the landlord saying that they were not gonna, they were holding back the rent payments because of the COVID, and the strategy decided not to pay. So the first thing, it happened. Okay, The actual situation is that, of course, the same as happened with Adidas, is that stores and also offices of these huge brands all around the world are remain shut down by the state of emergency that was declared in most countries. Even that it's quite early, I'm not afraid, and I'm also prepared to say that the COVID crisis is already a big financial crisis, as Javier was saying, and it looks like it's going to be a severe one. So I think for our market in fashion, we have to bear in mind that mostly all the stores and the shops are located in the most expensive areas in the city, which obviously with an important impact in the financial problems arising with the rents. The companies are basically demanding from the lawyers and in-houses and advisors, what can I do? What can I do in this scenario? I have my shop locked down. And of course, there's a huge modification of the preliminary or the statements and the agreements that made by the landlord and the tenants at the time being. So what should I do? Should I keep on paying the same rent, although the situations and the circumstances are totally different? Can I stop paying the rent? Can I apply for force majeure clauses or terminate the contract? Can I apply to a different clauses like revoc sic stantibus or hardship? Or what should I do? Should I go for a contract novation that will help me to face the situation? Okay. Okay, so the first thing would be, my advice would be, go back to the contract. Go back to the contract and reread carefully and review your contract. Many rent contracts are just standard, but bear in mind that there are many commercial stores, retailers that might have clauses that could help to face the problem. Here in Spain, we have a special regulation for rental that it's obviously very open to the rental contracts for companies. So please analyze the possibilities of both parties and what can we offer to the other side. Maybe there's a chance of talking about rental review, but we can put on top of the table something that could help the other side to accept that rental review. Maybe we can talk about mandatory terms that could help us and to negotiate with the other side, or maybe we can also offer some other offers that could be interesting for them. It's not a question of 100 to 0 or 0 to 100. I see personally a question of maybe facing it in a 50-50 or what we call win-win basis. It's also important that we see who is in the other side. Who is the other side? Is it a big tenant? Is it a small investor, family office, big financial group? Many decrees have been passed in many jurisdictions. I can assure that they've been taking into consideration that for big tenants or also for big financial group, the possibility of negotiating is lower because there have been some decrees passed already now, and here in Spain, one especially yesterday, that it's obliging to the big tenants to offer at least financial helping. It's also important that we take into consideration that rental agreements are long-term contracts, and for that basis, they have a different treatment. We need to talk to our client on the first place and find out what's the situation of our client. Is the situation financially hard for my client only for now, in the meantime, where they keep the close shut down, or is it financial difficulties that we'll have to face for the coming months? As I was saying at the beginning of my presentation, it's obvious that the situation is going to last at least for a few months, if not for a year from now. And we will have to find out with our client whether this situation would be, or this negotiation will have to be for long-term or just in short basis. If the client can comply for, as I was saying, financial issues or any other ones, or for internal decisions in the companies, it's important that we take into consideration the notifications to the other party. Either way, notifications to resolve the difficulty in a friendly way, through a resolution or agree on innovation of the country, or if it's not possible because there's no way of having this open and friendly argument with the landlord, take all the measures to try to comply, and also keeping the accreditation of them to prove in the coming future that the non-compliance was an inevitably non-compliance. It's important that we understand that there are many options that will give us a certain way of trying to novate the contract. And I want to bring on top of the table 3 important things that we have and tools that may be used. The first one would be negotiating, explore the use of the ADRs, the alternative dispute resolutions, and work together to find the best and fastest way for closing the novation of the contract. That's very important. Negotiating, talk about the BATNA, the best alternative to a negotiated agreement, and identify the best alternatives out of the agreement. I would highly recommend to avoid court disputes, and not only by the framework, what we call here the mutatio livelli, or by the long situation that could arise, but because many jurisdictions have right now, the courts are closed, and we probably find out that by the time that we have a ruling, we probably, our company will have to make other decisions or take other decisions that will probably tougher. Think about mediation and arbitration and try to find external experts. It's also known that there's many companies that have, or they belong to associations and probably to important groups of associations that could give us, or could have experts, external experts, meaning that mediation or arbitration can be a very, very good solution. Mediation, as you probably all know, it's based on the agreement of both parties and has a mediator in between that could help us to find the best way, but only as an external advisor, and the agreement will be just taken by the parts, which is a very fast and a very easy way of implementing the novation of the contract on, let's say, 1 or 2 days as long. We can also find, or we are seeing now, that many court arbitrations are also implementing fast-track systems by giving us experts in rental agreements in all the market, and that could give us also some advice and make it easier for us as a short arbitration with less form demands, and that would probably give us the possibility of ending a novation of the country, a novation or a ruling in maybe 1 month from now as the longest. What we have here is from the technical part of view. I would like to talk now about what's the situation and how would be the technical approach. It's known that the contract is the law between the parties, what we call pacta sunt servanda. This is what it's agreed by both parties that has to prevail. And this is what, as I was saying at the beginning, it will be sustainable for both parties. But as we also say in here is pacta sunt servanda, will, if not revux sic stantibus, meaning that the contract is the law between the parties, but only if the circumstances at the time of the agreement remained unaltered. The revux sic stantibus is now a clause that it's here in Spain, was also applied lately by the Supreme Court, and we have two important rulings, one in 2014 and another one recently on 2020, that based, as I was saying, in good faith and the retention of the contract, will outlast the covenants to review and modify the agreements between both parties on a temporary basis, and meaning that we can change the principle, meaning rent agreements, thanks of these parties, and taking into consideration that it's been a very strange situation, that it was amongst everything. The three important things that we have to apply, or they apply for applying this clause, will be the economic fundamental of any given contract have been materially alterated, that it was such unexpected alteration must not be attributed to any of the parties pleading, and that such alteration causes are unreasonable and, of course, economic burden to one of the parties. If these three situations are given into the situation, we might have the possibility of pleading to the Supreme Court. And that was, I will wait for your last comments if there's anything that you need to show, but for now, I think it's important that we carry on with the next presentations. Thank you, Javier.
Well, thank you. Just an organizational question that I forgot to mention at the beginning. We'll accumulate all the questions at the end so that we will have I think a more fruitful debate if we make at the end to all the panelists, so that any of you can jump if you have any. So thank you very much, Milagros. Very interesting. Now our following speaker is Stephen SIDKIN. Stephen is a partner of the London-based law firm Williams. He is an expert in digital matters as well as in IP matters and distribution and supply agreements. He's also a member of the Fashion Law Commission. Stephen is one expert in fashion houses in the United Kingdom, but also worldwide. And Steve would provide us his perspective regarding the threats and opportunities that COVID-19 represents for distribution and agents in this new global context. So, Steve, the floor is
Javier, thank you very much indeed, and I hope that the sound quality is good. If it isn't, please, Javier or Colette, please tell me. So, let me start, first of all, by making sure that the slides work for me, but let me start. So, I wanted to start by way of introduction by just drawing attention to 4 fashion brands which operate primarily in the UK, but which are also operating elsewhere within the European Union. These fashion brands have all been in the financial and fashion news over the course of the last 5 weeks. And the reason is purely and simply with regard to the impact which COVID-19 has had on each of them. It has affected them very badly indeed. And as a result of that, each of these brands has announced, and in the case of Primark has slightly gone back on the announcement in terms of what they are doing with their suppliers. I mention that because whilst that of itself is outside the relationship of the brand and the distributor, the brand and the agent, I mention it because it's important to take account of something which is critical within the fashion industry, and that is the supply chain between the parties. And so we have a situation where the brands in front of you, Topshop, Debenhams, Urban Outfitters, Primark, have each chosen to say that under the terms of the agreements that they have with their suppliers, they can delay payment, they can reduce payment, they can say that they will accept the goods if the supplier accepts a reduction of 30% of what was the agreed price. And it is important to bear in mind when we talk about the relationship between brands and their distributors and agents, that we have in some situations the intervention of law over and above the contract, the intervention of law which protects distributors in some countries, the intervention of law which protects agents throughout the European Union and the United Kingdom. We also have a situation where, despite that, various parties within the fashion industry will seek to take advantage of their commercial strength. And we have a situation where the industry is renowned as being one where informality is key. To find a fashion brand which has a full suite of agreements in place with its customers, with its suppliers, is very rare indeed, certainly so far as the UK is concerned. So please bear in mind those opening comments. So let's talk about what are brands and distributors thinking about at the moment in respect to payments and order cancellations. I'm going to look at it from the perspective of the brand, and I think that thoughts are likely to be at three levels. Firstly, where there are goods which have been supplied to the distributor, but which the distributor has not yet paid for. And in this situation, if the distributor becomes insolvent, it will be crucial that either in the distributorship agreement itself or in the terms and conditions of sale, and preferably both, that the brand has retained title to the goods supplied. If this is not the case, then the brand will be an unsecured creditor in the distributor's insolvency. So if the distributor goes into liquidation, title has not been retained by the brand, then it can be expected that the liquidator of the distributor will seek to sell the goods. And the liquidator will not account to the brand for the monies owed by the distributor. Instead, after paying their own costs and paying secured and preferred creditors, then any surplus that is left over from the sale of the goods, and it is likely to be very little, if anything at all, will be divided up by the liquidators between unsecured creditors as a group, and one of the unsecured creditors will be the brand itself. Not a good position for the brand to be in. But even where retention of title has been included, as a matter of English law, then it depends upon the actual words used and the sequencing in which the order from the distributor was accepted by the brand. It may well be the case, and indeed I can think of a situation in 2017 where we were acting for a footwear supplier to a large UK retailer which became insolvent, that the sequencing of the order and the acceptance of the order was such that the client was left in a situation where it had failed to retain title. So the words used and the sequencing can be critical in terms of protecting the brand. But what have attempts made already to cancel orders? It would be surprising if a distributor had not thought about cancelling an order. If the distributor is then supplying on to retail stockists in a particular country, which is in lockdown, and we can all think of our favourite countries where that is the case, then the distributor may well be thinking about ending or cancelling the order which it has already placed. And I say that bearing in mind of where we are in the calendar. We are now towards the end of April. Certainly by the beginning of July, supplies will start to be made to distributors for onward delivery to retail stockists of autumn-winter 20 product. Really? Do they really want that order to come through, or would they prefer to cancel it? So the starting point is, again, the contract made between the brand and the distributor. But even where a supplier can and does refuse to accept cancellation, does that get the brand as the supplier into any better position? Because even if it is forced to deliver against the order because it has been unable to cancel the order, then what of getting paid? And again, we go back to the issue of retention of title. It's also possible to envisage a situation where the distributor looks at the relationship, looks at the distributorship agreement between it and the brand, and seeks to achieve cancellation by the back door. And here, what it is trying to do is to find a reason to turn around to the brand and say that the brand is in material breach of the distributorship agreement. For example, the brand has been selling online in a way which was not permitted by the distributorship agreement into the territory of the distributor. Perhaps the distributor has known about this for some time and chosen to turn a blind eye to it. But now the distributor is in a position where it may suit the distributor, if the agreement permits, if the law governing the agreement permits, to say, aha, that was a material breach of the agreement. I'm going to rely on that in order to end the agreement, in order that I don't have to take the order, in order that I can escape without making payment or being liable to make payment to the brand. And then finally, does the distributorship agreement cover force majeure? Last week, there was a UIA webinar which addressed various contractual issues, one of which happened to be force majeure. In summary, it depends upon whether or not the words used in the agreement in respect of force majeure can extend to cover the concept of COVID-19. And already we are seeing disputes arise in the UK where parties are, unsurprisingly, trying to argue one point or the other, as the case may be. So, an opportunity for distributors? Possibly. Does the distributor want the agreement to continue? We've already touched on that in some way. Perhaps the distributorship agreement has a number of years to run. It has minimum purchase obligations. It has non-compete provisions. Perhaps the distributor is looking at what has happened, the impact of COVID-19, and saying, okay, let me see if I can find a way out of this. Perhaps I can do better if I was free of the distributorship agreement itself, so far as the particular brand is concerned. It is a very rare business anywhere in the world at the moment, in my view, that has not thought about conserving cash. And one way of conserving cash is to look at your relationships with your customers, your relationship with your suppliers, of which the brand is one, and think, okay, do I want to somehow get out of this relationship? Can I use COVID-19 as an opportunity to do so? And does the law provide particular protection so far as distributors are concerned? Well, in the UK, it is the case that English law and the law of Scotland and the law of Northern Ireland does not provide particular protection, but we also know that in some EU member states, Belgium is one, I believe Germany and Spain are others, the law does, as a result of either decisions of the constitutional courts or legislation which is in place in those countries, the law does protect distributors. The same is also true in other countries around the world. Brazil, I believe, is an example. South Korea, I know, is. The UAE is. And it can be expected that distributors looking at the relationship between themselves and their brands will be thinking about seeking to take advantage of the law that protects them in the event that they do find themselves in a situation where the relationship comes to an end. And then again, as discussed before, when looking at it from the position of the brand, it's important to take account of what is in the distributorship agreement itself. Is it possible to rely on a force majeure clause? Is there an exclusion of what English lawyers call a right of set-off? so that the distributor can say, yes, I owe you for the order that has been delivered, but you, the brand, were in breach of the distributorship agreement. You have caused me loss. I'm treating that loss as being set off against the monies I owe you. And what is material breach? English lawyers can have a lot of time and a lot of fun discussing what is material breach in respect of any agreement. So these are issues which are important for the distributor to bear in mind, as it may provide an opportunity arising from COVID-19. So lastly, I want to turn to the position of agents. Now, we've already established that both the supplier and the distributor, both the brand and the distributor, may think, yes, let's cancel the order. But what about the situation where the order has been obtained by the agent? And in that situation, is commission still payable to the agent when cancellation occurs? I think it depends. I think, first of all, it depends upon the terms of the agency agreement itself. And then it depends on the contract which has been made by the brand with the distributor or with the direct customer. Many agents have written agency agreements. Usually these will set out when commission is payable to the agent. But irrespective of that, certainly within the European Union and within the United Kingdom, the agent's directive can provide certain rules to determine when commission becomes due and when commission which has become due is payable to the agent. The directive goes on to provide that agreements between principal and agent to derogate from these rules to the detriment of the agent will be void. And as a result, such an agreement will be incapable of being relied upon by the principal in order to avoid payment of commission to the agent. So where we have a standard provision, as we do in many agency agreements, that the agent will be paid commission when the principal is paid by the customer, then that simply may not work. And when the principal decides to accept a request from a customer to cancel an accepted order and a contract is in place, then the regulations distinguish between where the contract for sale is not fulfilled for a reason for which the principal is to blame, the brand is to blame, in which case no commission is payable. No commission is payable, and situations where the principal is to blame, and in that situation, commission is payable. What is blame? Well, there's a lack of case law to tell us what is blame, but we can all think of situations where we can say, yes, there was blame, or there wasn't blame, so far as the brand is concerned. So, lastly, some take-home points so far as this particular aspect is concerned. For a principal to be placed in a situation, and therefore for the brand to be placed in a situation where it will not be paid by a customer because of the way in which the order has been cancelled, and still has to pay commission to the agent because of the operation of the directive, that is double jeopardy. To avoid double jeopardy, it is better for a principal which is inclined, is minded to accept cancellation, to request from the customer's unilateral cancellation of the order. But a customer is likely to be unwilling to put itself in a position where it unilaterally cancels an order and then faces a claim from the brand for damages for breach of contract. And for the agent, knowledge is key. Knowing why the principal is not fulfilling the contract can put the agent in a position where it may pursue a claim for unpaid commission, and from that could even say, right, non-payment of commission is a breach of the agency agreement, and here is my claim for compensation under the directive. So with that, I think, Javier, there is questions and answers at the end. So please, I invite you to pass on to the next speaker. Thank you.
Okay. Thank you very much, Steve. Very interesting approach indeed. Aligned with what Milagros was saying, and you also said, we see that there is a lot of short-run decisions, some based in good faith, other triggered by necessity, just to survive. We will discuss about this because I think it's really interesting, the difference or the difficult to balance how to manage this short-term crisis with long-run and long-standing relationships that may last longer than this crisis. You know how to balance with this in the agreements. Thank you very much. Just one minor comment. We are 114 attendees, but we have only one question, which, by the way, it's a good sign that we are explaining everything fantastically and there are no questions, or maybe that our audience is a little bit shy. So please, if you have any question, please feel free to introduce it in the panel that it is ready for questions and answers. So, thank you very much. Our next speaker is Marita Dargallo. Marita is the president of the IP Commission. Marita is partner of the law firm Buigas, and she's an expert in IP and e-commerce. And she will explain how e-commerce has a relevant key role for fashion houses. This is out of any question. It's only one of the very few channels, commercialization channels, that fashion houses are having nowadays with this process. And she will explain the regulatory framework that has been shaped by recent decisions by different regulations worldwide. So Marita, the floor is yours. Thank you very much.
Thank you. Thank you everybody for joining this webinar. And as Paco mentioned, I wish this would move. Okay. Sorry, I don't seem to be able to move the slides. Okay, great. The new regulatory framework I'm going to be referring to is mostly the framework that has been put into place by Spain. I would suspect that most of countries worldwide are experiencing the same differences, and probably the Spanish provisions are going to be echoed in a number of countries. As you may know, in Spain, as from March 14th, the state of alert was declared. All shops were closed to the public, with the exception of essential supermarkets, banks, surprisingly tobacconists, and newsagents. However, the good news for the e-commerce is that e-commerce was allowed to continue to operate. The same as commerce over the telephone and commerce over the postal service. However, in this first initial declaration of the state of alert, we see already a provision that suspends all the statute of limitation and expiry periods of rights and actions pending the state of alert, which already is something that affects the normal relationship between manufacturers and consumers, because such things as the liability for defective products is suspended until such time as the state of alert is finished. As a result of the state of alert and the negative impact that COVID is having for the economy, the state has been issuing a series of decrees and urgent measures. And I'm sorry, because I tried to click for the next slide and okay, thank God, maybe I'm not pressing hard enough. Anyway, so after the first declaration of the state of alert, the government has obviously realized that there is a tremendously negative impact for the economy and for rights of consumers, for everybody, because people are locked in at home and industries are locked down. So, I mean, they're trying to alleviate all this situation. So thinking of e-commerce and also brick and mortar, one of the measures adopted by the government was to say that while the state of alert was running, people would not need to return those products that they have purchased and they had decided to return. This, of course, affects the right to desist in any online transaction, which normally entails the return of the good. Okay, you don't want it, you want your money back, you return the product in the same state, minus perhaps some expenses. What is the rationale between such a sort of precise provision? Well, I mean, if you confine everybody to their homes, you certainly don't want them to run around returning parcels to the post office for all those goods they order and then return, because, I mean, as e-commerce is working, people are indeed buying, and as we will see later, they're buying a lot. Another provision which has affected the way consumers are operating is contained in one of these numerous royal decrees that we have been issued with these days. And in fact, I would like to tell you that slide 3 and 4 have suffered a modification thanks to a royal decree that was approved yesterday. And if you bear with me, I will explain how it now works, because the government obviously realized that the provision wasn't very clear and decided to amend it. Anyway, what we have now is that if during the state of alert, a consumer comes to the conclusion that an agreement or a service that had to be provided during the state of alert cannot be fulfilled because of COVID-19, they can serve the seller or the service provider a notice of termination and ask to be reimbursed of the money. It is not an automatic termination, because in fact the law says that you have to have 60 days in which to try and negotiate an alternative solution that will restore the balance to the agreement by issuing a voucher, offering to deliver late, give the service at a later time. However, if after 60 days from the time that the notice was served, the parties have not reached an agreement, then the termination is final and the seller or service provider has 14 days to deliver payment to the consumer. What happens, in fact, is that if you count the days, they are giving sellers and service providers 3 months in which to reimburse a consumer for something that they're not going to be able to render or sell. And in fact, what the government is doing is giving like a working capital to all these companies during the time of the alert. It's giving them a breather. And there is some concern as what will happen once the state of alert is lifted. How many of these companies are going to be able to face an avalanche of requests for returning purchases or services? There's also a provision for ongoing agreements where you're paying monthly quotas, so the quotas are suspended, and then they can be the agreement cannot be terminated unless the parties both agree to do so. And I mean, this is really desperate because I'm clicking away like mad. I'm very sorry, but this doesn't move. Okay, and those ongoing agreements, they can offer that the payments, monthly payments, can be suspended and then resumed after the state of alert finishes, and the consumer can request that those quotas that were paid during the state of alert are reimbursed. There are also provisions that affect package holidays, which I would think will apply to all countries, at least in the European Union, and also for flights and so on. The Spanish government, with respect of e-commerce, has issued specific guidelines to minimize the impact of contagion, and so has delivered instructions. You will see once you download my presentation that I've put a link so that people who are interested can find out what these measures for food delivery, click and collect, hygiene measures for packagers and for food are applicable. But this is quite specific, so I thought maybe only those persons interested would like to look at it. If we now go to consider how e-commerce is doing, I would have to say that e-commerce is doing very well. So far, according to the National Association of Big Distributors, online commerce for products is up by 23% with respect to the same period in 2019. If we consider that 52% of these sales correspond to imports, we can tell that e-commerce is doing well and is doing globally. If we take an example, but such as supermarket sales, which we know that supermarkets are open to the public. So we see that sales in supermarkets, physical supermarkets, are up by 23% with respect to the same period, but that online supermarket sales are up by 48%. This means that people who had hitherto never made their shopping for normal household goods online are doing it now. And the same applies to home technology, where online sales have risen by 45%, which is tremendous. And this is because a lot of people are working remote. So they have set up their little office at home and they need technology, so they're buying online. There are other indicators of the well-being of online commerce, and some of it surprisingly, not surprisingly rather, is that corrugated cardboard production is up by 13%, as if compared with last year. And corrugated cardboard is what makes the boxes of the likes of Amazon, but also the boxes of home produce from markets to the marketplace. All those are made in this kind of cardboard. And I mean, it is a very big increase. We have also seen an upsurge of online marketing, and this is mostly done in-house and can be done in remote. And certainly a very big increase of influencer marketing. Why? Influencers are used to organizing their same shoots, their own shoots. They don't need to go outside. They are, part of doing it from home is a reflection on their lifestyle. And this has allowed them to continue to operate in the times of COVID. And in fact, we've seen the Spanish administration resort to influencers to promote such things as washing your hands and social distancing, and this was addressed to young people. If we now go to e-commerce in times of alert for fashion industry, I'm afraid that the scenario is not as rosy as for supermarkets or home technology. People are buying food, they're buying toys for the children in confinement, they're buying sports equipment because everybody's doing things, following sport lessons online. They're buying sanitizers, but certainly they're not buying shoes, they're not buying clothes, and they're not buying perfume. So what has happened? The sales of fashion houses have fallen generally by 85%. This is according to the Spanish Association of Textile Manufacturers, ACOTEX. And online sales have fallen by 80%. These, luxury took the biggest hit. And the reason is that luxury purchases, for the big luxury brands, usually take place on bricks and mortar shops, because buying in a luxury shop is part of the consumer experience. They will use online to track the good, they will look at limited editions, compare prices, but more often than not, the final purchase is done on the brick and mortar. And what happens, all the luxury shops are closed like the rest of the fashion houses. So of course companies are trying to catch up and try and reinvent themselves and move on, but it's not being easy. Last week we read on the newspapers that Zara, whose shops like everybody else's have been closed down, and production is very reduced, because if you can't put the clothes on the shops, I mean, you're only going to concentrate for your online sales, discovered that some of the goods that consumers were still demanding online, they had finished their stock. But then of course they thought, okay, hold on. I mean, all these clothes, they are hanging on racks at the physical shops. So they requested 800 volunteers out of their own workforce, which is now at home waiting until such time as the shops open again, to go into the shops and rescue, quote unquote, those dresses, shoes, whatever, that were being demanded through the online sales channel, and they have been channeled back so that they can leave the shops, at least by e-commerce. Other houses are, increasing their online marketing. They are doing campaigns. They're having sales. They're offering reductions. But of course, I mean, if you think that people like the Outnet, which is like the sales version of Net-a-Porter. Today I received a notice on my email saying, okay, we are gradually going to start delivering again. You can tell that even, I mean, with online commerce, they are not doing well. So basically the general feeling is that the spring-summer campaign from the point of view of the reseller is going to be quite a write-off. Francisco, if I have a few minutes or 2 or 3 at most, let me know. I would explain a little bit where I think that online commerce is going now on the wake of. Yeah, can I?
Okay, 1 minute.
1 minute, okay. Basically what I wanted to say is that COVID has been a very big opportunity for online commerce, because on the right of the concern for safety, they have been able to penetrate into households where before people were not buying online. And this concern of safety has been able to balance the impatient of online consumers. You have Amazon Prime, you want everything bought delivered to you in hours. So people are waiting and they are not complaining. And why? Because nowadays, if you want a yoga mat, or you get it through online commerce, or you don't get it because you can't go to Decathlon yourself. So that has given them a big opportunity. It has also put them to test, because there's been production problems, there's been logistic problems, and there's been delays everywhere. However, I think that as we emerge from confinement, the safety concern is going to continue, and that is going to be giving wind to the e-commerce sales, because people are going to want to be delivered at home because they're going to be scared. They're going to be scared to go into a shop, mix with a lot of people, and at least for the few months coming over, we will see that it's going well. But they will have to reinforce logistics. They will have to have urban storerooms. They're going to have to implement contactless collect and delivery, so that it is sealed and on a cupboard, or you will have a QR to open it. And if the trend progresses, we are going to start looking at a different problem with real estate. But I think that is for another time. Thank you very much. And I will be taking questions at the end.
Thank you very much, Marita. Very interesting and practical indeed. As you mentioned, e-commerce is the only gateway for fashion houses now, but they have to face the decline in the request of products, as well as this new jigsaw legal framework across Europe that is shaping the rights for consumers and e-commerce as we know now. Just one quick comment that you mentioned, why is tobacco, that it was surprising tobacconist network to be open. This is a discussion that I had with my wife. I think that this is because otherwise the ratio of murders in Spain would be 2 or 3 times if you cannot purchase tobacco. So thank you.
Yesterday on television, they said that nicotine was maybe good for COVID. So basically, visionary and the government had this, I can't, it's the only reason.
Yeah, indeed. Thank you very much. And our final speaker, it's Mr. Fabio Moretti. There are many things we can say about Fabio's resume, which is like 10 or 12 pages long. I will try to summarize them. Fabio is the former president of the Fashion Law Commission, so he's our president of honor. Fabio is a founding partner of Moretti Burgio Associates, a law firm based in Milano, Venice, Florence, and very specialized in matters regarding fashion law. Fabio is a top reference in the world of fashion law. Fabio was the former counsel of Armani, as well as from Benetton, and he currently, in addition to his firm, he is also a member of the Venice board. Fabio will talk about very singular and unique element that has happened in the fashion industry, which is its temporary conversion in war times to manufacture different garments, sometimes for free and sometimes not, and he will explain about this, in order to join the fight against COVID-19. Thank you very much, Fabio.
Thank you, Javier, and good evening to everybody. The topic I'm going to briefly talk about is how, for a short time, the fashion industry and the luxury industry have created a change that was, in a way, has been in a way quite remarkable. In fact, when we think at fashion, we are quite accustomed to concepts like lifestyle, like beauty. More recently, we see a lot of fashion brands involved in the concept of sustainability. But the reaction that I saw from the fashion world, particularly in this country, but not only in my country, is can be summarized in one word, which is solidarity. Actually, the COVID-19 has been very tough here in Italy. That was the first country to be affected by this virus, and affected in a dramatic way. You all know that we had an impact that started to be quite evident at the end of the month of February, although there were some significant signs coming from Asia and from China that the virus should have impacted the country and Europe and the rest of the world quite significantly. Nevertheless, our government took some preliminary measures, as I said, at the end of the month of February, early March, in order to create some zones called red zones for a total confinement, in the hope to stop the development of this illness, but which unfortunately did not succeed. So starting from the 8th of March, the government declared a total lockdown for the country, although the infection was basically concentrated in the areas of Lombardy. Milano, as you know, is the center of the economic and financial activities of the country, so this was a very tough and dramatic thing to see, in the area of Veneto and in the area of Emilia-Romagna. The timing was such that the country showed to be dramatically unprepared to face this emergency. And this is not a fact that we have seen only for Italy. We have seen this also for other European countries, and not only European countries. But having been Italy the first European country to be so strongly impacted, this resulted to be as a very dramatic event. And in particular, the authorities and the health institutions realized that there was a dramatic lack of sanitary tools, like protective masks, for instance, like overall protections, like valves for respirators. As you know, one of the consequences of this virus is pneumonia, a dramatic pneumonia. So respirators need to be provided for those that need intensive care, and hand sanitizers. All this was not produced in the country, and So Italy had dramatically to look for these supports in the different corners of the world, right at the moment when all the other countries had to do the same, because these productions were basically concentrated in Asia and in some other countries. So in order to face this unprecedented challenge, the fashion world responded in a way which was very, as I said, that showed a lot of solidarity. So the answers by the luxury goods industry started from the Camera Nazionale della Moda, the fashion chamber, National Fashion Chamber, organizing a very important fundraising that was followed by other specific fashion brands like Valentino, Armani, and others. And these fundraising efforts was called Together for Tomorrow, and Italy, we are with you. Nevertheless, from some other brands, it was realized that the presence of some raw materials and the presence of production capabilities might well lead to a specific support in those tools that I just mentioned. Protective masks, overall protection, valves for respirators, and hand sanitizers. Talking about masks, I assume that nowadays all of us are expert about what masks mean, unfortunately. We can divide these tools in three areas that are identified by the way they are useful for. So some type of masks are called selfish masks because they basically protect the person who wears the mask. Some others are called unselfish because they protect those that are in front of the person who wears the mask. And some other are so-called intelligent masks, in that they have the effect of protecting both the subjects. A lot of brands in the fashion industry decided to utilize some raw materials and some of their production capabilities to produce the so-called unselfish masks, because these were, by the way, also needed, dramatically needed by nurses and doctors. And in fact, we saw a gigantic effort by Armani, by Gucci, by LVMH, by Prada, in order to produce and to donate those tools to the health authorities, and this was highly appreciated. But then also the perfume industry was in a way supportive in this difficult situation, this difficult environment. And we saw, in fact, for instance, L'Oréal in France producing a number of hand sanitizers and providing those for free. And we saw Bulgari doing the same. And we saw Campari even doing the same thing. Campari, as you know, is a producer of alcoholics. And so they decided to use part of the alcohol that they had in stock and to create a common an on-purpose joint venture with another company called Intercos to produce those hand sanitizers that will also enter in their, they declared that they will be entering in their standard production and so in the future we will see them. But then also Ferrari, the luxury car producers, did something. And in fact, they realized that they could have used part of their production tools for the production of valves for respirators. And this is what they did. And they provided those valves free to the Italian health authorities. We also see another, a producer of sports tool, Decathlon, that is producing those particularly snorkeling masks that have been so successful last year with this innovative style or whatever. They realized that those could be used to support people who were affected by the virus and could have difficulties in breathing and in a pre-pneumonia phase. So all of this we saw not only in this country, thanks God, we saw it all around the world. And as I said, was a very important sign of how also an industry like fashion can show solidarity. But which are then the legal challenges that we can see in this type of situation or in this type of legal approach? And in fact, to the extent that those brands are using their names and their logos for some of these sanitary tools, they had to check whether the trademark was actually protected for this area, which is certainly not the standard type of activities for fashion and for luxury. Also, another important point was and is to check the mandatory provision of law concerning the legal requirements for those tools. And this, in this type of situation, we see a lack of common rules within the European Union, and each country basically has its own. So we hope that as one of the consequences of this dramatic pandemic will also be a kind of uniform, a creation of uniform rules. We saw also other things that were quite surprising, at least to me, which were related to trademark infringements. In fact, we see online protective masks bearing logos of important brands that are totally unrelated to the activity of the brand. So we see now these brands that are also engaged in the fight against counterfeited goods, bearing counterfeited masks, counterfeited sanitary supports that bear their trademarks. Thank you.
Well, thank you very much, Fabio. Very interesting. Yeah, this is a unique situation, and I think that despite all the crisis, the response from the industry has been really outstanding and amazing. So thank you, all of you. And now we have some time for answering the questions posed. So to start with, I would like to start with the first question that was addressed to Milagros. It's regarding a question regarding rental agreements, and the question would be, where is the balance that, okay, let me rephrase it, but it would be something regarding, okay, we have stores closed, this is true, but where is the balance when these stores have certain premises, sometimes in the store itself, but sometimes attached to the store, or not, or in the store itself, but not open to the public, where these fashion houses are storing their products. So where is the balance, you know? Because yeah, of course, stores are closed, but then you are still using them as a storage space. What are your views on this, Milagros?
Yes, sorry, I just had a problem with the with the computer. I think basically this is some of the key questions that were rising concerning the rental contracts. And there was many people saying that, of course, as far as we're keeping on storaging, there's no room for asking for a review of the rentals. But we have to see that, or we have to face that problem only in terms of activity, and what's really causing the unbalanced situation. It's not only the storaging, but the sellings of the shops and the retailers. So I think even though there's important people saying that as far as we need the place for storages, we don't have room for asking for novating the contract. I don't see it that way. I see that we basically have to base our demands on the significant lower sales that we will have in stores and the activities. Although that Marita was saying, I think it's really interesting that the e-commerce has increased substantially. In terms of rental agreements, I think we only have to take into consideration what's the situation of the store and what are we selling, and if the numbers and the figures are significantly low, I think there's room for asking of the unbalanced situation. So my question will be that this won't stop the possibility of asking for a renewal, or for a review of the rental, sorry.
Yeah, thank you. There are several questions, as a matter of example, from Mrs. Marta Carmona and from Mrs. Valentina Maturana regarding counterfeiting. Fabio already explained about this. Even in solidarity terms, we find counterfeiting. The world is really sad. But how do you see? Have you? I know it's still soon, as Valentina was pointing out. But do you see, or do you believe that there is going to be an increase on counterfeiting with this boom on online marketing, or being online marketing the only channel? And what about cyber squatting? This is another question that was posed by the audience. Do you think that cyber squatting is going to increase? I mean, we've seen this, for example, that has been a lot of fraudulent registrations regarding COVID-19 or COVID-19 tests across Europe. But what about cyber squatting, sorry, for fashion houses? So how do you see, Marita?
Well, I mean, looking at Fabio's example, and I have seen it online myself, we can imagine that there's going to be face masks of all possible denominations and non-authentic. But that's a joke. I think that COVID-19 is the kind of trademark that you cannot register. And with the onslaught of e-commerce, yes, of course, there would always be cyber squatters, and there would always be people trying to use a domain that evokes another person. But I don't think that would be very different from what we are seeing to date. I mean, as it increases, well, you know, we will continue to fight them. Of course, thanks to GDPR, it is now more complicated because we don't really know who's behind a domain name if they put it on private. So the whole process of dismantling a squatter's domain becomes a bit more complicated, but we still manage to go by.
Steve, Elizabeth Lenjo asks, what strategies would you advise fashion brands to empty now that collections will be behind seasons? I think that here the role of distributors and agents would be key. So what's your opinion?
Sorry, Javier, can you repeat the question, please?
Yeah, that Elizabeth asked regarding the fact that with this impact of COVID-19, for sure this season is gone. What would you recommend to fashion houses to empty or to sell this stock at a reasonable in a reasonable way? And I really think that here the agents and distributors, as you mentioned, would be very important. So what would be your advice?
It's a very difficult question, but let me see if I can offer some thoughts. The first thought is that for any fashion brand now in a situation where it has stock in place so far as the current season is concerned, spring summer 20, it is a case of shifting that stock as quickly as possible. It will have autumn winter stock coming in from manufacturers, one hopes. I'll come back to that in a moment. And it needs to shift the stock, it needs to generate revenue as quickly as possible. If it has an online presence, and if it is able to maximize that online presence, and we've already spoken about that during the course of this webinar, well, that would be great. Reference has been made to the role of influencers. I think that that will increase significantly in an attempt to try and help move the stock which brands have for spring summer 20, which they would otherwise sell in store as opposed to online. Brands have to up their online presence. They have to they have to increase what they're doing online to try and shift that stock. If they can't, then perhaps in some instances where it is what we might call staple products, which are going to be used throughout the year, then they might try and hold back the supplies that will otherwise be reaching them coming in over the next few months in order to run down the existing stock they have and spread it out, help the cash flow, both in terms of payments out and in terms of money in. That might be an answer for those brands which have a significant staples element as part of their portfolio of styles. And then we've got the question of the manufacturers. Quite a few of the brands that we can all think about will have a product manufactured in China. China has been in lockdown or large parts of China have been locked down for the best part of 3 months. Production has been slowed, absolutely. What's going to happen then in terms of getting the product made and moving it from China to, in the case of all of us on the panel today, to Europe? Does that mean, therefore, that autumn-winter stock is going to be delayed? That's good and bad. Good in terms of cash flow, possibly. Bad in terms of actually being in a position where your competitors have placed orders perhaps with Turkish manufacturers, which haven't suffered to the same extent as Chinese manufacturers, can therefore be getting their product into store insofar as stores reopen, can get their product for autumn winter online, and to try and carve out a competitive advantage as a result of delays or non-delays, China versus Turkey, so far as manufacturers are concerned. Each brand will have its own problems, its own difficulties, its own challenges, but also its own opportunities. And I do see that for the foreseeable future, brands will be focused increasingly on the online market, and they will shift revenue in terms of spend onto that market as they try and compete one against the other.
I agree. Thank you. Fabio, one question that Calgulati mentioned is if you have identified any specific problem, legal or regulatory, for the fashion industry regarding this reshape. You know, if there is any impediment or not in order to shift and start producing this kind of goods that you mentioned.
Well, I must say that all the actions that I described were taken on an emergency basis. So they were taken in order for them to become effective in hours rather than days. So in those activities, certainly a great degree of care has to be taken, and a lot of attention to the regulatory matters have to be focused on. In my experience, or in also talking to some players in the fashion industry, I saw them taking actions even before making a thorough, a complete legal analysis about potential challenging situation concerning also potential risks. But as I said, it was really, and still is in a way, but fortunately decreasing, but it was really a dramatic status of need. And let me also say that as far as I'm concerned, I see a difference in a situation where a company is acting and producing the tools that I described to donate them, to make them available for free, rather than conducting, rather for those companies that are probably planning to conduct a business activity, for instance, on masks. Some might also consider this to do it in the future. I see a difference also from the legal standpoint.
Thank you. Yeah, in Spain it's similar. Another problem that I completely agree with you, and another problem that I see is that some of these measures have been taken on a national basis, and this complicates very much the situation for those companies willing to help in some countries in addition to them. So I completely agree with you. It's a very complex matter, and of course each country has adopted different measures, and some have taken expedite measures or procedures if the product is going to be donated to healthcare professionals, but then these procedures are not the same if it's for self-use or if it's to be commercialized. So yeah, it's a complete new world, and I think that I agree with you. Authorities have not yet thought how to manage it properly. So I have there is a final question for all of you. It's a little bit wide, so let's try to, if you want, just to be to give your opinion on this. It has two sides. It posed by Robert Hart. The first part of the question is for you, Steve. Clearly, it's if the UK had not left the EU on 31 January, it's impossible not having you and not speaking about Brexit. Sorry. Could the UK have taken advantage of the EU structure, or put it in another way, it's the UK on a worse position regarding COVID-19 for not being an EU member? And the second question, it's for the rest of you. Do you think, because it's especially addressed to Italy, but I think that this could be also addressed to Spain for sure, and I would like to hear about Marita and Milagros, if you think that our governments or companies could take any action against the European Union for the lack of coordination in this a sort of action against the state, or do you think, or at least shape it, if you think that there should have been more or could be more coordinated action in order to mitigate this risk on a European
Can I maybe take the floor? The European Union does not have health competences. Those belong to the member states. And in fact, health protection is one of the reasons that you can actually defect from some of the normal free circulation of goods, capitals, product, whatever. Member states are allowed to put more stringent measures. Maybe the fact that we're going through this pandemic with everybody running around like chickens without a head is maybe a possibility to have further cooperation, because what cooperation there has been because of the member states themselves willing to do it. France has sent patients to Germany. Italy has been informing the Spanish authorities because they were 1 week ahead of us. There are exchanges of information, particularly between investigators, and that is very good news, because I mean, we can all die, so people have decided to get their act together. But I don't think that the European Union should be blamed for lack of coordination on health issues, because it's not her duty. I mean, if we want it to be the duty, then we can discuss about it. But I mean, we are now talking reconstruction, then we can talk about something else. But health issues are not her, it's not her domain, I think.
If I may add 2 words in that respect. We always see a situation where we have an international political crisis and the member states blame the European Union for not having taken a foreign policy position, a clear foreign policy position. But the foreign policy is not something that is is for the European Union. That each country has its own foreign policy. The same is true for this type of situation. So I think that what comes out of this dramatic experience is that also in this field, we will need more Europe, not less Europe.
Completely agree.
Sorry, Javier, can I follow on from Fabio?
Yeah, under pressure, because he was a defender, he defended the European Union and you're out, so no pressure.
Okay, well, at the moment, well, no pressure. There's a lot of pressure on the UK at the moment. At the moment, the UK is in the situation where it is in the transition phase from leaving the European Union. My starting point is that of a convinced Europhile. I regard the UK leaving the European Union as the worst decision the UK has made in the best part of 1,000 years. So that's my starting position. It emerged earlier this week that the UK government had lied in terms of why it did not join the scheme that was available to it to join, to engage in the procurement of medical products throughout the European Union. The UK government has lied, and it has been found out. And I do hope that in time to come, and it won't be this year, possibly won't even be next year, but I do hope that the UK government is held to account by the UK population for that. And that is a very personal view. By way of a closing remark, just turning away from Brexit, one thing that we haven't touched on, which I think is going to significantly have significant implications so far as the fashion industry is concerned, is that in the UK, we are seeing fashion brands become insolvent, going bust, to use the colloquial expression, on a weekly basis. In fact, it is rare that we do not hear about brands in trouble on a daily basis. Those brands that survive, whether they are big or small, they will find themselves in a position where there is less competition, and that will be very good for them, but not good for those who have gone bust, not good for the shareholders of those who have gone bust, not good for the employees of those who have gone bust, and not good for the landlords of those who have gone bust, and so on and so forth. But it will have a dramatic effect, I think, across the European Union, across the UK, across large parts of the rest of the world, as brands have gone bust, making space in the market for those that remain.
Agree. Yeah.
Let's say two words. Just two very fast words. I think this is a global crisis, and from my point of view, we need to face it globally, and we need to push one to each other and try to help each others. So I don't see this situation as doing it only as our own governments. Unfortunately, as Steve was saying, we have kind of risky situations in some countries that we may say and we know. But agree with Fabio, with Marita, more Europe will be a very important thing for all of us. And apart from Europe, I think the world will be a better place after that pandemic situation, because we will all be I'll bear in mind that we need to take care of many other things that we haven't lately. So it is important that we think in win-win, and we decided to do everything in good faith. As far as I'm concerned, this is what I'm going to give, and the maximum advice I will give to my clients, not to take advantage of the situation, but to stay together and to do it as good as we can.
Thank you. Thank you very much to all of you. Thank you very much to our attendees. We have more than 100 people online. Thank you very much for your attention. We really hope that you enjoy our webinar. I think we touched very interesting and cutting-edge topics. I would also very much like to thank our 4 excellent and outstanding speakers. They provided a very interesting and thoughtful standpoint of the situation. So thank you very much to all of you from the effort, from Barcelona, London, and Venice. We connected worldwide. Thank you to UIA for giving us the opportunity to provide this webinar. And of course, I would not be a good president of the Fashion Law Commission if I don't make 2 final remarks. First of all, please buy fashion garments. You are still on time. We have e-commerce, as Marita very well explained. It's an industry that it employs a lot of people worldwide, from manufacturing to distribution, retail, etc. So you have to support the industry, and it's also culture. So we have to support it, and of course you have to join UIA and to join the Fashion Law Commission. So I really hope that you all join us. Thank you very much, and have a nice weekend.
Thank you. Bye.
Thank you, Javier. Bye-bye.
Bye.